Okay, guys, I'm gonna put the main screen and then we're gonna go live, okay? Wait for the timer.
Perhaps you control them, muting and unmuting.
copyright my PowerPoint page.
Yes.
I will read the exercise.
Washroom here? That. Oh, good to see you. Sit over here lah, then you'll appear on camera. Hello everyone. You are at the event Complex Mediations for a Digital Age Masterclass for Stakeholders. A warm welcome to all of you who are with us here in Singapore, and greetings to all of you who have joined us virtually from around the world. Shout out to Eric Tuckman, Senior Vice President and General Counsel of the AAA-ICDR. He has flown into Singapore to participate in the Singapore Convention Week, and we invite him now to say a few words.
Welcome to the American Arbitration Association International Center for Dispute Resolution's Asia Case Management Center in Singapore. We've got a great program this evening that's part of the Singapore Convention Week. Complex for Mediations in the Digital Age, a masterclass for stakeholders. And with that, I will hand it over to Francis Goh.
Thank you, Eric. A big thank you to our host, AAA-ICDR Asia HQ. Want to acknowledge Michael Lee. He is the Vice President of the AAA-ICDR, and he directs the Asia HQ based in Singapore. Also, Ashta Chavla, Director AAA-ICDR Asia Case Management Center. Pamela E, International Liaison. The team has been working very hard behind the scenes so that we can all be here tonight. A little about the event. It is Singapore Convention Week. Hectic back-to-back events, speakers, and panel presentations. We thought that we will do something of a slightly different pace. We got together 5 professional mediators, all passionate about mediation in their respective jurisdictions. We wanted them to share best practice tips to guide us all in this complex age that we live in. Well, tonight, sit back and have a listen to our sharing. A few words about our panelists. I'm Francis Goh. I'm from Singapore, a mediator since 2001. I am a semi-certified mediator. I'm also active as a mediator, skills trainer, coach, and assessor. I'm on the panel of the SMC, the SIMC, and the AAA-ICDR. With me today is Lu Chang. He's from Honolulu, USA. Now, I'm going to read so I can do justice to my fellow panelists. Lu's been mediating business, commercial, and construction matters since 1984. He is an advocate and proponent of ADR processes, a faculty trainer of mediators and arbitrators in the USA and Asia Pacific since the 80s. We have also A.J. Jawad, big in India. He's been a mediator since 2007. He is partner and head of ADR services at KD Lex Chambers. Having extensive experience in mediating commercial, contractual, matrimonial, and child custody matters, he is also a trainer with the MCPC, Supreme Court of India, and has trained lawyers and judges in mediation all over India. He is on the panel of the Bombay Chamber of Commerce and also the SIMC as an India specialist mediator. We also have with us Yoshihiro Takatori, Yoshi-san for short. He's big in Japan, an executive director of the Japan Association of Arbitrators, co-convener of Japan Chapter Chartered Institute of Arbitrators, chair of Web Hearing Committee, Japan International Dispute Resolution Center. He has trained lawyers and judges in ADR, and he's the only Japanese lawyer in Financial Times top 10 legal innovators for Asia Pacific region. And to round off our panel, we have Harold Coleman Jr. from California, USA. He's an American attorney and arbitrator, mediator and conciliator, conflict coach and trainer with expertise in complex commercial, construction, and consumer disputes. A panelist and on the training faculty with the AAA since 1987, Harold has also overseen various AAA mediation initiatives as the association's senior executive for mediation. So introductions over. Let's begin with a case study. Yoshi-san,
Yes.
you recently mediated successfully in a cross-border case. Can you please share with us as a case study?
Sure. Regarding the online full virtual co-mediation, I experienced as the co-mediator. So maybe for the purpose of setting up the platform for discussion, I'd like to go through the such case study. But before that, I really appreciate this opportunity. And thank you very much, Francis, and thanking to the AAA and ICDR. So first page of my case study, please. Okay. So first, the nature of the parties and the type of dispute involved, complex points. What are that? First of all, the disputes over a joint venture agreement between X Japanese entity and Y Indian entity. After X filed arbitration, X and Y agreed to mediate under the made-up type of protocol. And then joint protocol between the two institutions. Then complex points are mainly 3 points. The first one is a cross culture, sort of a typical, stereotype of difference, but still common law versus civil law and language difference. And then second, business concern. That means the joint venture should continue or such joint business should be terminated. And third, of course, the COVID-19 pandemic situation, especially in India, for continuing in business in India. And then second, operation of the online co-mediation, appointing two co-mediators. So first one, the online can be an efficient option even after COVID-19 pandemic. That's kind of a question. And then first, efficient combination of a joint and a private session, caucus session, utilizing Zoom function or any other online system. Then second, speedy and easy scheduling, the availabilities of a very, very busy arbitrators, mediators, like a Francis, very famous mediators are always busy and always on the airplane. But online protocol could be resolve it, although we have kind of time difference issues. Then advantage merits of a co-mediation for a cross-border case. What's that? Then an efficient reaction against different legal culture. Again, common law versus civil law, which is not so simple, but basically those type of a culture difference still exists. Then can be communication bridge. The co-mediator can be a communication bridge, including different language. For example, like English versus Japanese, or Japanese versus Indian, whatever. But however, the mediators are not messengers, not only messenger or not pure translators of parties, which sometimes parties might misunderstood. This mediator from our jurisdiction can be a kind of advocate or messenger or translator for us. But we said, no. The co-mediator should function as a one unit. And then but still can be a bridge, including language. That's next point. And then, very importantly, the appearance of a fairness and a credibility, because we have two professional, two co-mediators. If one mediator is saying something, if such way of operation attendance is not matching to the some parties, then could be cross. But if we have two professional, then such fairness, credibility of such operation and proceeding could be increased. So next slide, please. So another case study point is, which is, we call Greg Yoshisuke because, I did the co-mediated with the Gregory Vijayendran, who is a quite famous mediator and immediate former president of the Law Society in Singapore, and myself. We utilize sort of a schedule, especially for the online platform. We believe that's a quite efficient tool. That's why we are calling it as Greg's Yoshi schedule. Like it's like a red fan schedule, which is very famous for arbitration discovery things. But so what's the such Greg Yoshi schedule? First one is we displayed commercial objectives. We determine commercial objectives. Clear understanding as a starting point. And then confirm parties' agreement, understanding. So that should be fundamental direction of a future business. So in this case study, joint business should be continued or should be terminated. So that's a very big difference, starting point as a difference. Then second, quite key points for the mediation always, what and how we can pick up as a common interest between the parties. So common interest pick up and display, then confirmation of a party's understandings of a common interest, which was shown in a so-called Greg Yoshi schedule. So for example, of course, cost, timing should be saved, and then clear understanding of a future efficient business, and reputation, credibility in the market, of course, in this case, in India and Japan, and focus onto the business, even under or post COVID-19. Then third, we displayed kind of concrete items which were already agreed, which were already progressed, like to visualize the agreed points, reach the steps and items as a collaboration to the eye of parties. The parties can be getting satisfied. Oh, we agreed so much so far. But still, they have a non-agreed items. I should say, yet agreed items. Cannot be agreed. You can agree by your efforts and the collaboration. So difference and the reasons we displayed, points to seek for common interest and collaborate. And then depending upon the progress, on some points, mediator's idea may be proposed. That's a sort of a mixture of the evaluation type of factors but that's deeply dependent upon. So maybe we can discuss later. And then combination of the evaluative and the facilitative kind of a way, and a practical hybrid of common law and the civil law type of things. So that's the reflected in the non-agreed items kind of display. So that's my the inputs. And then last page, please. Sorry. Successful factors, we believe. The pre-mediation was very helpful and should be utilized to educate parties. So change of mindset from the disputes arbitration mode into collaboration mediation. That's a key. Then second, efficient and smooth combination and the communication of co-mediators with mutual understanding of the roles based upon mutual trust between the co-mediators. That's also the key. Then third, reasonable and amicable communication, including experienced and capable counsels, which is very important, despite of some hurdles, including different legal backgrounds. So we need reasonable counsels. Then fourth, lastly, the efficient support and backup by the supporting institutions like AAA and ICDR, including smooth online operation like today, and such as breakout rooms for private sessions, private rooms, parties rooms, and mediators room, of course. So that's the end of my report. Thank you, Francis.
Okay. Thank you, Yoshi-san, for that very comprehensive case study. Listening to you, it sounds like we have 4 areas to focus on: mediating in the digital space, culture, the role of lawyers, and process design. Let's unpack each of these areas as we have our discussion tonight. So, turning to the first area, mediating in the digital space. Have we lost anything by having to mediate online? Lou, over to you. I know you've got some views on this. Please share.
Okay. The virtual platform has been indeed a boom. It is so efficient that people love it, but it is a challenge. We have lost some aspects of what we are comfortable doing when we're in person. We need to start by recognizing that a virtual platform is considered a cold medium. It is not as warm, as complete as being in person, being able to look and talk and shake hands and break bread and the like. It's a much colder medium. And people sometimes appear less engaged or maybe distracted. They are multitasking. And so it's a challenge for the mediator to keep the engaged attention of the parties. We don't have the full range of body language, visualizing, and sensing that we can do when we are in person. So it's harder for us to show we care and harder for us to demonstrate and make an empathic connection with the parties, which we know is very critical in mediations. It's important to remember that many cases have both a legal aspect and an emotional one, and in those conflicts that have a strong emotional dimension, it is harder to address those on the virtual platform. And we also, I think, have to anticipate in cases whether being on site is helpful or necessary. We can do a site visit, we can observe a project, we can have a visual perspective, and sometimes that just cannot be completely duplicated on the virtual platform. But there are things we can do. It is more challenging to establish rapport and to earn and build trust in a virtual format, but it is doable. My takeaway points on that is the pre-mediation sessions become even more critical. So to personally connect with parties and with advocates, I encourage people to meet before pulling all of the decision makers together with the advocates, getting to know the advocates, getting their views, enlisting their help and support, and then separately, when possible, also have opportunity to pre-mediate, meet with decision makers, because they similarly need to be comfortable with you and with the process. And it's an excellent opportunity for you to earn trust and build rapport. Research tells us that pre-mediation meetings are best used to connect with parties, to try to earn their support, gain their trust, and the like. And we are warned by research to not use pre-mediation meetings to too early get into resisting parties, evaluating parties, negotiating terms. That can be done later. So that it's important to use these pre-mediation opportunities to connect empathically and try to earn the party's trust and confidence. And in these meetings, we can explore their dreams and hopes. We can explore their fears, and hopefully they will be comfortable sharing that with us, so that the more we know, the more and better we are able to help them. So we can use these pre-mediation sessions to gain their commitment, make sure we got the right decision makers involved, also to demonstrate our experience and concern and ability, and so that hopefully they can feel that they can trust you and they can have hope that you are comfortable with the process and expert and know how to help them. So you can kind of create that positive entry into the mediation process. It's also an excellent opportunity to try to warm up the cold medium, help the parties feel comfortable. So all kinds of things we can do. We can talk about the pictures in their room. We can ask them, what they like to do, all kinds of things. But we want to connect and humanize. So the virtual platform is a challenge. It works. It can work. It makes some things difficult, but it's doable.
Thank you, Lou. You made the point earlier about it being doable. Perhaps over to you, Jawad. What are the advantages of the online mediation medium?
Yeah, thank you, Lou, and thank you, Francis, first of all, for this opportunity. Just before I go into the advantages, I just want to share one thing on Lou mentioned about the opportunity of breaking bread. I remember watching this movie Oslo. It was a film on the Oslo Accord, the backdoor negotiations that were held parallel to the main negotiations that were going on between Yasser Arafat and Yitzhak Rabin. Now, these backdoor negotiations, there is a scene in the film where the negotiations are really becoming very heated. The arguments, the people start arguing with each other. And they're almost, there's a fear that there may be some violence. And that is when the person who organizes this meeting opens the doors and says, let's have lunch. Lunch is ready. And the whole atmosphere changes. And after lunch, they're having some desserts and drinks, and everything is back to normal again. So yes, that definitely we miss out on the digital platform. But let's also remember one thing, Francis, that Mark Prensky, I was reading somewhere, he writes that there are two kinds of people. One, those who were born before the 1980s, whom he calls as digital immigrants, and those who were born after the 1980s, who he calls as digital natives, because they understand the digital language. Now, if you look at the new generation, they are very comfortable in their digital world, because their shopping is online, their communication is online, their dating is online, they order food online, everything is done online. So they're absolutely comfortable. Now, we belong to the digital immigrants generation, where we are still struggling to learn the digital language. So that is where, we are facing a challenge, because those who were born before the 1980s, we are trying to adapt, we are trying to learn this new language. And that is where the challenge comes for us. So, but for the new generation, I don't think there's a challenge. And there's a whole new concept of digital body language that is developing. In fact, I was reading a very interesting book by Erika Dhawan on digital body language, how you communicate online. including how do you send emails, what kind of punctuation marks that you use, what kind of emojis that you use, and also the what kind of when you're on an online platform, what do you do? How do you really communicate? Now, I think one of the first things that we do when we meet people is we look at their hands. Perhaps that goes back to our hunter-gatherer days. When we see somebody new, we try to see whether they're carrying a weapon or something in their hands. Now, online, what happens is we are not able to see people's hands. So everything depends on your facial expression, your tone of voice, and I think also helps to show your hands up on the screen to show that you're not carrying any weapons. So we need to learn their body language, the digital body language, as Erika Dhawan calls it. And the fact that online mediation, for example, is space agnostic, time agnostic. Now, Yoshi-san was talking about this mediation that he did, a co-mediation, with people sitting in India, people sitting in Japan, and mediators sitting, perhaps, I don't know whether it was in Singapore or where it was, but in their respective places. So today we are now talking across, the digital divide. We are all in communication with each other. We are discussing so many things. So there are advantages, there are challenges. So what I see is the challenges are there, but the advantages far outweigh those challenges for the simple reason that one, we are leaving a lesser carbon footprint because there is less travel involved and there is less paper involved. And there is a whole lot of advantage to this because being time and space agnostic, we can sit in our respective places. Like I can be sitting at 12 o'clock midnight in India and doing a mediation with somebody who's in midday in the US. And I might be sitting in my pajamas and doing the mediation as long as I wear a coat on top. Nobody's going to know about it. So the comfort and the advantages that are there, particularly from the environmental point of view also. I think this is a very important advantage of the digital world. So I think digital dispute resolution is here to stay. And we have to embrace it and we have to learn that language as quickly as we can. Thank you, Franz.
Digital mediation is here to stay. So how can we as mediators ensure or make this digital mediation effective? So for instance, I myself, when I mediate over the digital platform, I highly recommend what Lou was suggesting, to take pre-mediation sessions to warm up the parties, build trust, build rapport, and just establish that connection. It just takes a bit longer, but it can be done. So let's go around the room here and just take one point. How would you make digital mediation more effective? Let's start with Harold.
Chef Francis, I will tell you, there's a whole body of research that makes the case that what mediators need to do is take leadership in helping the participants to have a better sense as to what's called online nuances and etiquette. Online nuances and etiquette. What do I mean by that? Is very typical maybe for a mediator, just as an arbitrator would do, to work from more than one screen. You've got one screen where, of course, you're interfacing with the parties and having dialogue. And there could be another screen where the mediator is looking at documents and things of that nature. Well, it's so interesting that if we fail to make eye contact with people and really give them the kinds of nonverbal cues to let them know that we're listening and we're kind of feeling what it is they're saying, which in and of itself helps us to build rapport. And we're looking away at a document on another screen, they may draw the conclusion that this mediator is really not in touch. Mediator's doing something else. Mediator, heaven forbid, maybe even checking email or surfing the web. So it's so important for a mediator as part of mediator's opening, or certainly maybe as part of what I call the technological prep that's necessary for effective mediation. It's no longer just about substantive prep. Let's think about your alternatives before you get to mediation. Let's think about really what your real needs are. What are the other parties' needs? What we call substantive prep. Also, the whole notion of technological prep is so important before we ever get to game day, as we say. So for that reason, learning a few things about mediation online etiquette is important. Getting parties and the participants to agree, okay, can we stay on camera? If for any reason you need to go off camera, can you simply make a quick announcement? You need to take a quick break or you're going off camera to do something. So no one feels disrespected as though, well, now you don't want to hear what I have to say, so you go off camera. Understanding privacy, confidentiality is all part of this, again, online etiquette and communication that needs to take place. So in addition to everything that I heard my colleagues, Jawad and Lou say, and I totally endorse and concur with what they're saying, I would say really be conscious mediator and take a leadership role in helping to instruct the other participants on some basic online nuances and some communication and etiquette principles that can make for a much more efficacious session.
You successfully mediated online.
You.
One point, or how to be effective.
Yeah. So two points. The first one.
2 points.
Yeah. Okay. Sorry. Yeah. As our colleagues mentioned, the key of mediation is the communication between the parties to facilitate the communication. So 2 aspects: the technology operation aspects. Educate on how to use technology, how to operate. And second, the substantial side, you need to educate the parties to make their mindset as collaboration. And also as I a little bit mentioned, for example, display like agreed points or no agreed points on the computer screen. That's quite helpful. Sometimes that could be better for in-person kind of mediation, because in-person mediation, maybe you have to bring the materials, papers, something. But computer screen, everyone can watch the computer. So then computer displays, such sort of a grandiose schedule, whatever schedule, everyone can be focused on. That's kind of powerful device, I think.
Okay, thank you very much. Lou, over to you. How to make it
like a mango. There's a certain ripeness to dispute resolution. So to help parties get there, I encourage them to share the information, make the information available so that people can make their business decisions. Make sure the decision-making authority is involved and present. And so if you reach an agreement, it can be confirmed and tied down and completed. But also invite the parties to modify. Make sure they understand they can help and make suggestions to change the process so that it works better for them. So I try to do those things to help make the online mediation more successful.
Thank you, Lou. Jawad, how do you make it more effective?
Yeah, I think both Yoshi-san and you made a very important point about the pre-mediation communications between the mediator and the parties. That, I think, if you spell out the rules and the etiquette, as Harold pointed out, what are the rules that you're going to be following online? And particularly, like, for example, keeping the camera on, muting yourself when the other person is talking, and laying down ground rules that there should not be any interruption while one person speaks, the other person listens, and also the kind of language that is being used, that the communication should be polite. That helps a lot. That is one. Number 2 is Lou, one more point which totally resonates with me, because I always make it a point to have a casual conversation with the participants when I'm doing a mediation, before we really get into the nitty-gritty of the issues that are there. Inquiring about their comfort, inquiring about them, asking them questions, some perhaps a few questions that about their work, their career, their family. That helps a lot in building up the rapport, which you would be otherwise missing, which you can do much better when you're face to face. So, to make up for that, I think a little bit of a casual conversation with the parties before you really start the mediation helps a lot. And since it's only your face that is visible, Francis, I think it's very important how you keep your facial expressions, what kind of listening attitude that you demonstrate, for instance, your nodding of the head, the extenders that you use, and showing them that you're interested in what they are speaking, and asking them the right kind of questions, asking them more clarificatory questions, summarizing what they have said. All these small techniques, which we call as active listening, become all the more important, I feel, on the digital platform, because it becomes all the more challenging for you to build the rapport with the participants. So, resorting to all these basic mediation techniques you normally would do in in-person mediations, you do that a little more consciously and a little more efficiently in an online mediation. Helps to develop that level of comfort with the participants.
Okay, thank you. Great tips for effective online mediation. Let's go and unpack the second aspect, cross-border mediations. These throw up a whole different set of issues. For example, you may have a US party that's mediating with a party in India. They may have different attitudes to mediation or different maturity in each jurisdiction. Perhaps let's go around the room and you can each share with us what's the mediation maturity like in your jurisdiction. Lou and Harold. Lou, perhaps you start off and Harold can add on.
Well, I was going to defer to Harold. I think.
Okay, Harold, off you go.
I'll be happy to. I'll tell you, mediation in the U.S. has pretty much normed, if you will. It really, really started to pick up and proliferate in the late 80s and in the 90s, and largely because the federal courts, all the way from the U.S. Supreme Court to the lower courts, really got behind mediation, and many of the court systems created what's called court-connected mediation. And it was so interesting in the early 90s when I started practicing. Still, mediation was kind of new, and so many lawyers would say, well, why would I ever want to do that? That's going to be a sign of weakness. Why would I want to do that? I prepare my cases for trial. I don't prepare my cases to sit around and talk about how to be cooperative in trying to settle them. And while did that change quickly, again, with the influence of the courts. So now mediation practice has pretty much normed. In any kind of litigation in the U.S., parties know that there is going to come a point in time when they are, in fact, going to have some earnest mediated settlement negotiations. As a matter of fact, one of the statistics in the U.S. is very simply that in the federal circuits, only about 1% of the cases in civil litigation actually see the light of day of a courtroom, actually go to trial. The vast majority of them they actually experience a directly negotiated settlement or a mediated negotiated settlement. But the settlement rate is very high, about 85% of all of those cases. In the state court systems, the statistic is equally high. About 95% of all civil litigation resolves without a trial. So therefore, lawyers have become very, very comfortable with mediation in the U.S. Now, having said that, we've noticed some real, what I like to call mindset shifts that have occurred. And one is there seems to be a much more of an appreciation now for the need to get our arms around what I call the human factors of mediation. I mean, think about it, any kind of a dispute. In a sense, we have three buckets of factors. You have the legal factors, and those are important. And we have perhaps the business factors that come to bear when parties have to look at options and determine, what is their best case scenario, and really what would a prudent decision look like. But importantly, and what I have found in my practice, oftentimes to be the epicenter on which good quality decision making turns is on the human factors. And Lou said something earlier about, in most cases you have an emotional component and you have a legal component. I agree with that. I even expanded to say in all cases, in virtually every litigated case, you have a legal case and you have an emotional case. There are emotional issues that need to be dealt with for people to get out of that area of the brain where a lot of negative energy, negative emotion may exist. And it could be anger, frustration, sense of betrayal, resentment, all these kinds of things that escalated conflict can produce. For them to be able to deal with that in a safe environment such as mediation, give expression to it, have a mediator acknowledge it, and then help them make that transition from the emotional center of the brain to the rational center, where then logic and rational decision making, weighing of options, objectivity, all these things come to bear. Requires patience, it requires skill, and something that, quite candidly, in the US, American lawyers have not really been that sensitive to as mediation has matured through the years. So, what we're finding in many of the trainings that we're doing at the association is that there's a new interest in the intersection, if you will, between psychology and the law, psychology and dispute resolution, and getting our arms around the human factors. And I'll speak a little bit more to this a little later when we talk about cultural competency. But boy, does that become important, Francis, in the context of cross-cultural and intercultural disputes, which we'll speak a little bit to more perhaps later.
Okay, thank you. Jawad, over to you. What's the view like in India?
Francis, I just want to confirm whether my screen is visible, because for me it seems to be frozen.
We hear you and see
I hope
you
you're able
perfect.
to see and hear me.
Yes, we
Okay,
are.
thank you so much. Okay, see, the situation in India is exactly the opposite of what Harold described in the US. See, we are a fairly high context culture where there's a lot of deference to authority. And we have inherited a legal system, a colonial legal system, to which we are so addicted today that we find it very difficult to move away from that and to take responsibility and take decisions on our own, which mediation is for. That's a bit of a challenge because, Francis, one very important aspect of Indian culture is the joint family system, where we have a patriarch who controls all the family's assets. The entire decision-making process rests with that patriarch. And he always calls the shots. And that also translates into the business environment, because many businesses in India are family-controlled businesses. So where the head of the family always calls the shots. Now, what happens is, because you are virtually trained to obey, you're trained to listen to your elder person or the patriarch of the family, you are rather scared to take decisions on your own. So you always look for something which has a seal of authority coming from somebody like perhaps a judge or an arbitrator. So you're more comfortable getting a decision from somebody in authority rather than taking a decision on your own. And the concept of justice itself is slightly different here, because justice is perceived as only that which is rendered by the courts. Justice is not understood as you being able to resolve your own problems and reaching a resolution that would be in your best interests. So that is a bit of a challenge in India. But there is a lot of hope, because mediation is a fairly new concept of in India. We started actually seriously looking at mediation from 2005 onwards. when the first court-annexed mediation center was established in my high court, that is the Madras High Court. But after that, there was a lot of resistance from the legal community, from the lawyer community to mediation. It was perceived as what is called as, alarming decrease in revenue. So they perceived it as something that is going to be affecting their source of livelihood. There was a lot of resistance, but we are now witnessing a transformation that is happening. And I have a lot of hope, especially with the younger generation, because the younger generation is coming out of this high context culture or this joint family system. And we are seeing more of nuclear families coming up. We are seeing more people coming out of the stranglehold of the joint family and trying to establish and do things of their own. And especially when I'm training students in mediation, I find that they adapt to it much more easier than what I find happening to lawyers and judges who have been fairly entrenched in their belief systems. So I see a lot of hope for the future, Francis, but as of now, I would not say that we are really doing too well in the mediation field. We hope that things will improve in a very short while. We are looking forward to the mediation law coming into force in India, and we hope that things will change after that, perhaps.
Thank you, Jawad. Yoshi-san,
Yes.
what is it like in Japan?
Yeah. In Japan, historically, the mediation had been operated by as the court process. Okay, that's deeply linked as the litigation system. For example, my wife is a judge, actually, so that's why I'm litigating every day. But anyway, she handles more than 200 cases simultaneously. Okay, that's kind of average. That's almost impossible to write all judgments. Okay, so then they are naturally eager to let the parties to accept the sort of settlement. But that's not only the reason. But sometimes the judges, of course, are evaluator and the decision maker. And decision maker is sometimes make some evaluation, or even some judges might be threatening against the parties. Okay, if you do not accept this, then I shall write down or you will lose something. That's kind of an ultimate case. But anyhow, such very evaluated but the civil type of the mediation has been going on as a kind of a history. But now, more cross-border aspects, of course, judge cannot do a cross-border type of mediation. So that's why I'm, as Francis, you could introduce myself kindly. I'm kind of training judges, okay, please change your mindset sometimes, to be more facilitated, okay? Through the mediation, you should not only threaten the parties or educate the parties, sometimes to pick up common interests between the parties, to grasp some aspects of the facilitative aspects. That's we are now making efforts.
I see. Well, in Singapore, the rules of court were recently amended in April. So we've got Order 5 now that basically places a duty on parties to explore amicable resolution of their disputes before proceedings, during proceedings, and even before an appeal. So, Harold, you made the point that mediation has normed. I think we are at the cusp of mediation being normed, and this amendment to the rules of court might bring us further down that road. So what we're seeing now is the need for quality mediators and parties, disputants, who understand that they now have power in their hands and it's not just a box-ticking exercise. But let's move on now to look at culture. There's the stereotype of the West and the East. And in the East, we talk about face, we talk about guanxi, we talk about relationships. So let's talk a bit about culture around the world. All right, so Lou, over to you. What does culture look like in the US? And how does that affect mediation?
Well, Harold has accurately described what has largely happened across the country. Wholesale comfort and adoption of mediation process. But people are different, and we still have different kinds of advocates, and some have a difficult time, perhaps, or you kind of wonder where their interests really are for their client or for themselves. So we still have to deal with the recalcitrant advocate, but largely that's not the case. I was going to suggest that with the recalcitrant advocate, one thing we do in mediation when we ask to get involved with meeting the decision makers beforehand, we have an opportunity to return the dispute to the parties and away from the advocates. I mean, we don't do this starkly. We have to do it very carefully and subtly. But the dispute belongs to the parties. And if we can connect with the parties and talk to the parties and frame the discussion in terms of what makes sense for the parties, it will help to overcome a non-cooperative advocate. I don't know that that's necessarily a cultural thing. It's just it's a spectrum of different parties thing, where you have most who are very supportive and welcoming of mediation, and some who are not. So I hope that helps.
Okay, thank you, Lou. Jawad, what's it like in India on culture?
Okay. We all know that India is a huge country. The fact is, in India, every 200 kilometers, the culture changes, Francis. And we have about 122 major languages and about more than 1,600, dialects that are spoken in India. So if you're talking about multicultural society, I don't think any other society can compare or come anywhere near what India is, and that has its own challenges, as you can very well understand that. But there is something that is very common to all these cultures, and that is the hierarchy, the family affiliations, the importance given to relationships, and these factors play a very important role when you're mediating. And in the mediation, especially because I do a number of matrimonial mediations, and I always say that in India, it is not two individuals who get married, but it is two families who get married. So the whole family is involved in the process. And not just the parents of the couple, it might be the uncles, the brothers, the aunts, so on and so forth. So many times, what we find, not just in matrimonial mediations, but also in commercial mediations, we find that the person who comes for the mediation, though he may hold an authority in writing that he can take decisions or she can take decisions, but ultimately the shots are called by somebody else who's way higher up in the pecking order. And this person will always tell us that, okay, after we are nearing an agreement, and at that point of time we will be told that I have to get this cleared from my boss. So we routinely face this problem. So we take the additional precaution of asking this person, in case we reach an agreement, will you be able to take a call on it, or do you have to go back to somebody else? So we get this clarification before we really start the mediation. So this is one of the biggest challenges that we face in India. And there are there are cultural aspects. Like, for example, we were conducting a training program, and the question was, can a mediator accept any gifts that are given by any of the participants? And we said normally mediator should not, because it kind of compromises on your neutrality, or at least it affects your perception of neutrality. And then one of the questions that came up is the betel leaves. India, in many cultures in India, especially if you go to the north of India, people chew this betel leaf. They call it pan. And it is traditional to offer pan to anybody whom you meet. So whether you go to somebody's house or you go to somebody's office, you'll be offered pan. And it is impolite to refuse it. So this, one of the participants stood up and asked us that, what happens if one of the parties gives me pan? So for a minute, I come from south of India where pan is not such an important thing. So I was a little confused by that question. Then I realized that, okay, this is what he's talking about. And I said, it's perfectly all right to accept the pan. So these kind of problems, I wouldn't call them problems, but these kind of challenges do exist in India because the culture keeps varying everywhere. And you have to be very careful about whom you're dealing with, because there are so many religions that are here, there are so many belief systems that operate here. So it can be quite a challenge if you're not aware, or you're not conscious, or you're not alert enough to recognize as to which issue is coming from the cultural perspective.
But so over to you,
Yes.
Yoshi-san. In Japan,
Yep.
what is the cultural issues like?
Yeah, historically, the justice has meaning kind of a fine truth. Okay, so that's why rather than more advocate type of style, more on to the judge, or evaluator, decision maker should find truth. That's the justice. That's kind of a historical way. That's why we do not have in a court proceeding. We don't have a without project this concept. Okay, decision maker will suggest settlement something, and then the and also for negotiation style, Japanese corporations sometimes some sort of bureaucratic type of quite complex decision making process through the director board meetings, approval or something would be necessary. Then second, but my recent observation on the Japanese corporation, but not only limited to the Japanese corporation. So such global corporation like Toyota or Nissan, whatever, those Japanese corporations are not pure Japanese anymore. They have a lot of subsidiaries in US, a lot of the subsidiaries in Europe. They are engaging. They have retained American lawyers, European lawyers, who are educated in American way, in a common law way. They are very used to like discovery or facilitative mediation. So already, even Japanese corporations are getting to be a sort of multi-jurisdictional, global sense. So through the mediation system, you can communicate them, and you should catch what's the real sense of those companies. So you should not stuck only, oh, this is Indian company, this is Japanese company or something. You can communicate more, find out way of their decision-making process and thinking way. That's my point.
Don't treat corporations as homogeneous. Harold, over to you. You were talking about some cultural points earlier. Why don't you?
A cross-cultural mediation experience I had many, many years ago in my early days of mediation, and it really taught me the importance of, as part of a mediator's preparation, to really get a handle on the cultural differences. I mediated a commercial matter involving an American company and a Korean manufacturer. So, I go ahead and do my preparation the way I typically did, and I'm almost thinking fallaciously that is one size fits all. So the way I do my cases with American entities, it can work here. So I hadn't really considered the cultural differences, and I was amazed that during the mediation, just how stark those differences were. Example, as is so typical in the U.S., negotiators have this notion that, well, we all know what this is about, and the mediator has received our written submissions that we call briefs, And so let's just get right down to business. We need to get some offers going, get some settlement offers and counters going, etc. Whereas the Korean contingency, you could see it was a much bigger picture in mind for them. They wanted to ask more questions. They wanted to kind of get a better understanding as to where the American counterparts were coming from. They weren't interested in rushing into a negotiation. And then when we started caucusing, I noticed that every time there was a round of proposals being exchanged, the American contingents kind of made decisions kind of quickly on it. They kind of sensed, what they really liked and didn't like. Whereas the Korean contingencies, it was interesting. It was a little bit more of an involved process. They had to consult with others who weren't even in the room. It was just much more, in a sense, almost a little convoluted process. It wasn't really direct. And it wasn't until many years later that I learned from actually having taught mediation, the work of Edward Hall, who was an anthropologist, and he penned the title Beyond Culture. And it's interesting, Jawad spoke a few minutes ago to this business of high context cultures. It was Hall who did research and showed that certain countries are what we call high context in communication style, and others are low context. So what does that mean? It means very simply this: the communication meaning is in the cultural context of that party. So just as a real quick illustration, look at what happens in low context culture. And by the way, US kind of leads, according to Hall's research, leads the pack in terms of low context, whereas other Asia, as an example, is a very high context culture nation. Example, communication in low context cultures tends to be direct and to the point, whereas communication in high tech context cultures tends to be a little bit more indirect. Low context cultures value individualism. Okay, I can go on my own. And do you have the right parties of mediation? You have the necessary decision makers here. Yeah, I've got the authority. That's it. High context cultures value collectivism. The decision making is more of a collective. I see Jawad acknowledging that, and I can tell, Jawad, you've taught on this too. It's a real more involved process with other surrogates and influencers who may not even be at the table that need to be consulted. And mediator and counsel need to appreciate this. Because why? We know one key reason that many negotiations fail is simply going too fast. So now when I mediate cross-culturally, I'm really trying to help, especially my American colleagues, to slow down. Slow down. There's more here than meets the eye. You can't rush into a negotiation when you're dealing with persons and entities from high context cultures. Relationships take on a whole different meaning in high context cultures than they do often in low context cultures, which think is largely about the money and the stuff. And it really may not be. There may be a whole range of other things that are very, very important. And the last point I would make is this, is that in low context cultures, they tend to be very rationally based. Logic kind of predominates their thinking pattern, a bias for rational thought. In high context cultures, feelings, and is very experientially based. So there's that dichotomy, there's the interplay again between, in every litigated dispute, you have a legal case and an emotional case. And one psychologist I know says, always deal with the emotional case first. Why? Because you can deal with those needs for the experiential and how I feel about this before we get to the logic where we then start exchanging proposals and weighing them objectively. So my point is very simply this. I believe that the homework, the nature and the quality and the extent of the preparation when we are mediating cross-culturally is absolutely huge. I believe that case, in terms of a resolution that everyone will embrace and feel the process was a good one, and an efficacious process, it can be directly related to the extent to which the mediator appreciates and understands the party's cultural context, assesses their cultural awareness of one another, okay, explores and acknowledges, helps them to acknowledge the cultural differences and make a genuine good faith effort to bridge those gaps. That can oftentimes directly influence the quality of the outcome. Cultural context is absolutely huge, and it begs everyone's attention before we ever step foot into that mediation conference room. Why? Because one size does not fit all.
Well said, Harold. As mediators in cross-border mediations, we overlook culture at our peril. Now, I'm mindful of time marching on, and we want to reserve a big portion for the process portion. But let's just touch on the aspect of lawyers. Lawyers are involved in all mediations. Is there a role for them? And how does a mediator work effectively with lawyers? So just 1 point each around the room so that we can deal with this point quickly. Lou, let's start with you.
Lawyers are critical to the process, but we have to recognize that lawyers are a different breed of cat. They have different interests and concerns, but we still need to make them an ally of ours in the mediation process. And we do that when we have those pre-mediation discussions by inviting their participation in designing the process, finding out what their concerns are, why the case didn't settle. Are there personality issues? Are there trust issues? Are there missing information? So we present ourselves to them as we can help them get their case resolved. So that's how I would approach trying to work with a lawyer that I've not worked with before.
Thank you, Lou. Jawad, over to you.
I would just like to stop by simply saying ditto to whatever Lou said, because even I agree that lawyers are absolutely critical for the mediation process, especially where it arises from some civil or commercial dispute or contractual dispute. Because from the legal perspective, they are the experts, and I would prefer to have them by my side as my allies when I'm mediating a dispute.
In Japan.
Yeah. Okay. So maybe cannot limit it to Japan, but in addition to the role of the counsel as an advocate, I would like to emphasize the importance of the role of in-houses, especially for mediation. They should be familiar with their business, of course, and also they should control outside counsel, including the fee. Okay. So, for example, like essential standardization patent disputes, you are fighting in US, Europe, Japan, China, whatever. If you retain each jurisdiction's lawyer, they love to continue the litigate disputes. So then, some lawyers may tend to proceed with their discovery or something, but in-houses who are understanding the business and they should control. And as a center, okay, so you should have a comprehensive and time-saving resolution as arbitration or mediation. That's the key, which only in-houses can do. That's my point.
Okay. In-house counsel, pay attention. You have a role in mediation too.
Sure.
Harold, over to you.
Location. When it comes to the role of counsel in mediation, I say prepare as follows. Number one, counsel lets you and I work together to prepare your principal, your participants for mediation substantively, emotionally, and attitudinally. Substantively, emotionally, and attitudinally. All three of them have to work together. Secondly, counsel, please let us prepare for mediation and prepare to present for mediation and not litigation. There should be something qualitatively different with the tone and the delivery of the presentations that occur at mediation so that they are not characterized by adversarial posturing, but better by a spirit of cooperation. Who says we can't be competitive and yet cooperative at the same time? So while we have agreed to step into this safe harbor called mediation that's characterized by calm waters, not tumultuous waters, that's characterized by collaborative and hopefully constructive dialogue and not inflammatory rhetoric. Let's prepare for mediation, not litigation. You can always return to that tumultuous sea called litigation if you want to. But while we agree to be in the safe harbor, let's really, really tailor our presentation, our speech, our attitude, our very personas to mediation. And then thirdly, counsel, let's prepare to learn. Really, mediation in many respects can also be an opportunity to have a great learning conversation. And then from that learning, we can then make better decisions and we can really take stock of a lot of things we may have missed before if we only look at it as an opportunity for competitive bargaining. So let's look at it as a learning opportunity. And one last point I'd make quickly is I heard a very, very knowledgeable, high-profile lawyer say before, and I thought it was a very interesting comment. He says he always looks at mediation as an opportunity to get a peer review of his case. I said, how enlightening is that? He says, whether it resolves or not, and we hope it will, but even if it doesn't, I can get a peer review from someone I respect and who's knowledgeable and who's neutral. And I need to know that so I don't get blindsided if we go forward. I thought that was absolutely insightful at every level.
You. So, lawyers watching, you've got an important role to play, and we want to collaborate with you as the mediator so that we have a good experience for your client. Let's move on to process design in cross-border mediation. Personally, I am big on pre-mediation because I find that this sets the tone, it gets the homework done, it builds the rapport, it gets people warm, builds trust. But what are your views on it? Harold, pre-mediation.
Pre-mediation, I believe it's, again, consistent with this cross-cultural awareness that's so important, is to first, I believe it takes a series, to tell you the truth, Francis, of pre-conferences, I like to call them, pre-mediation conferences, because really, in my view, mediation doesn't necessarily begin when we bring everybody together. That's just the convening phase of mediation. Mediation really should begin with that very first communication privately with each party. So what I like to do is have a pre-conference first just with counsel so we can get into these things we just mentioned a few minutes ago in terms of counsel's role and how counsel and I need to link in arms. So, we're soldiers in arms together, and let's work this hard and how we can best set the stage for productive mediation. And then the next pre-conference is with counsel and their client. I'm doing that with both parties. And all of this is happening before I ever convene everybody. It takes more time, but I think in the case of cross-cultural mediation, that is essential. And these provide opportunities to then, Francis, explore the cultural differences, the cultural expectations, their views of the timing and views of readiness. And if we're not yet ready to mediate outcomes, then how can we mediate process that can help ready everyone to come together where we can mediate outcome? All of this should be, in my judgment, fleshed out through the pre-conferencing that's a necessary precursor to the actual mediation, not unlike what surgeons do before they ever step into that operating room and they actually do the procedure as a mediator. That's what we're doing. We're doing surgery here to help parties overcome some kind of physical malady. But there's a lot of prep that goes on. And then a final assessment as to readiness before they will ever submit that patient to a surgical procedure for a whole host of reasons, risk management related and otherwise. And I think the same is true of us as mediators, as healers of conflict. And counsel, again, have a huge role in this, but we as mediators have a leadership role, and we have to take charge of that.
Thank you, Harold. Yoshi-san,
Yes.
over to you. Your case study had a successful use of co-mediation. Tell us about how that process design may help.
Yeah, 2 points related to the pre-mediation, as you mentioned, Francis. The first one is the pre-mediation is definitely the way for the co-mediators to learn how the parties are thinking, how the counsels are thinking. Such kind of a thinking way, co-mediators can learn, and vice versa. Parties, counsels can learn from co-mediators how co-mediators are sitting to try to reach settlement. That's the first point. And second, overall, the pre-mediation is the let the parties to be ready for mediation. That means to ready for pick up common interest between not only for you guys, but also for their guys. So as a little bit mentioned, the Greg's and Yoshi's schedule. So commercial objects, they should think about definitely first. And then second, you should start to pick up common interest. What's the common interest for us and for them? So think about, start to ready based upon their reviewing other parties. That's my point.
Thank you. Jawad, can there be a creative use of joint and private sessions?
Absolutely, Francis. Because we normally what I follow is what I call it as shuttle mediation, and which is what my organization also teaches when we train mediators. In which what we do is we try to understand in the initial stages after the mediator's opening statement, after the convening the mediator's opening statement. We enter upon an exploratory stage where we try to understand where the parties are coming from, how their thinking processes, how they're looking at the whole dispute, and what exactly are their positions in that. And we continue further. We take them into private sessions and we talk about, we try to explore the fears and concerns that are, operating there. And what exactly are the parties feeling about this? What are their fears, their feelings, their concerns? And then we also do a sort of a reality check with them where we call it as a stage of destabilization, where we ask questions to them. How would you feel if this dispute is resolved? How has this impacted you? How has this affected you? And what are your future plans? So these things we try to do in the private session. And even the negotiation part of it, once we identify what are the issues that need to be resolved, we try to do as far as possible the negotiation also through the private sessions, because sometimes we find that people have these cognitive biases and they harden their positions when they're making offers. They hesitate to make an offer in the presence of the other party. Or when they are responding to an offer, they try to take a harder stand on that offer. So we sort of to play the role of a shuttle diplomat, carrying the offers from one person to the other person, but not before we test those offers with each person. So I think the creativity part of it comes over there in the negotiation stage, because when we are testing these offers and when we are encouraging the participants to come up with better and better offers, and when we are streamlining those offers, and we are trying to check whether these offers are genuine and whether they can really they can work out, whether it will be feasible and whether it will be acceptable to the other participant. So all these things we are able to do in these sessions. So we use the joint and private sessions for the exploration of the parties' interests, understanding of their positions, where they're coming from, understanding what the biases and prejudices are, and going into the private sessions to understand their fears and concerns and how this dispute has impacted them and what they would like to see as being something that would be good for them in the future, and then lead them into the negotiation part.
Okay, thank you, Jawad.
That's what we do. Thank you.
Thank you. Lou, you've been a mediator since the 80s. Share with us some from your bag of tricks. How would you process design for cross-border mediation?
Every dispute is unique. Persons, people, personalities, strategies, relationships. So we have to adapt. We always have to be open to customize the process to fit. We've not talked about mediation style. And I think that's an important thing to ask the parties and the advocates. What are their expectations as to the mediator's style and objectives and process? Facilitative, directive, evaluative, and understand that so that it's known to everyone. We also haven't discussed confidentiality and privilege. I make a big thing of that in our discussions to clarify that there is an expectation and an agreement that the entire process is privileged and not to be used in an adversary way. But I also make the distinction that confidentiality is potentially critically important because I am inviting parties to trust me, and they don't know if they can trust me. But if I make the commitment that I will protect information that they want to have kept confidential, that may help, and it's a test for me to gauge whether parties do trust me if they share with me information that they wish to keep confidential, as opposed to the concept of privilege. There's a couple of things that might be a little bit controversial that I would suggest you can consider. I would clarify whether they are comfortable with the mediator being free and having the discretion to decide who to meet with, when to meet with them, and the like. So, for example, can the mediator meet separately with counsels? Can the mediator meet separately with the parties without counsels? Can the mediator meet separately with the expert witnesses, if that would help the process? And the other controversial thing is clarifying whether parties are willing to agree that no one can terminate the mediation process without first conferring with the mediator. So that gives the mediator some ability to prevent the dramatic exit out of the door, or the slamming of the fist on the table, as people say, we're wasting time, this is it, we're going to end this. But if you have that commitment, you have at least an opening to perhaps calm things down and keep the discussions going.
Okay, some controversial food for thought, but I think certainly useful as you are dealing across cultures and you are trying to design the process. Takeaway points is be ready to adapt and be very, very mindful of cultural issues, and as Harold says, do your homework. All right, we've got just a few minutes left before the clock ticks down and our time is up. Putting on the looking into the crystal ball, as it were. Harold, some quick thoughts on where we are headed with mediation and ADR.
You know what? On a global scale, my intel is that mediation followed by arbitration with the same neutral serving in both roles, is actually picking up. There have been some interesting studies done by American Bar Association, the International Mediation Institute, some others on these kinds of hybrid processes. So that seems to be on the upsurge, if you will. Don't have time to go into the benefits and versus risks associated with that, but MEAT-ARB seems to be on the uptick. And then one other thing, too, I've noticed is that a variant of that, which is called ARB-MEAT-ARB, ARB-MEAT-ARB. So in other words, the parties go through an arbitration. They go all the way through an evidentiary hearing. Mediator crafts an award, but seals it. Then gives the parties an opportunity, now that they've heard the testimony and the evidence has come in and the arguments have been advanced. Mediator gives them an opportunity to have settlement discussions, perhaps without the arbitrator's assistance, maybe directly, but there is some kind of a settlement and negotiation process that ensues. And then only if that doesn't produce a resolution, then the arbitrator actually issues the award. I think that is absolutely fascinating. And from those I've talked to who have neutrals who've engaged that process, they say it has a very, very interesting high settlement rate. And I say to that, very simply, this ARB-MEAT-ARB process probably is the ultimate reality tester. Talk about reality testing, that's the ultimate reality test for the parties. So it doesn't strike me as peculiar that once the evidence comes in, they would in fact then find some way to settle that dispute.
San,
Yes.
what's the view like in Japan and perhaps the progress of Japan signing the Singapore
Right.
Convention?
Yeah, that's very kind of a key and important discussion that's going on. I hope, at least early next year we should sign, because even for implementing the mediation clause between the cross-border parties, if the one party is signing on the Singapore Convention and ratifying, and if Japan has not yet signed or ratified, that could be unfair. No? So even for the bargaining power type of a discussion, I mean, definitely, the Japan should sign on, and also for just a little bit even after COVID. I mean, for today's theme, the online mediation can be strong option. May not be default option or not, but still strong option, because some disputes can be very fitting to the online mediation, because some parties would not like to breathe the same air by some emotional reason or something. And the second, some mediators amazingly pointed out the online mediation is so useful for even in-person mediation. You cannot so much closely look at your face, but computer, you can do that. And third, the like a caucus session and the joint session, it's easily can be transferred by just switching, panel, and you don't need to bring computer or a lot of the evidence file or something to the other. A lot of due process concern, like how to avoid coaching or something like that. But mediation, a little bit, not loose, but more flexible. So then Japan should be one, good platform, including digital, technique. Something. That's my observation. Thank you.
Okay, thank you, Yoshi-san. Well, ladies and gentlemen, that is all we have time for today. It's been such a rich discussion with my fellow panelists. I just wish we could go on. But the Asia HQ has plans to do an article based on today's program, and it will include any questions that our participants may have wanted to ask, but we did not have time to answer. So feel free to send in your questions so we can deal with them in the article. Give your contact email to the Asia HQ so that you can receive future updates and resources. So, well, it leaves me now to thank my fellow panelists, Harold, Lou, Jawad, and Yoshi-san, who's with me. Thank you so much for taking time to be with us today. And once again, thank you to the AAA-ICDR Asia HQ for hosting this event. Thank you all for your time and attention today. Have a great evening and the rest of a week ahead.